Hello, everybody. It's Dave Neal, stand-up comic and host of Bachelor Nation News. We have an update to the Bachelor Clayton paternity trial that's happening June 10th. He's accused of being the father of someone's unborn twins. They never showed up. He's saying they never even did the whoopee, and he's got witnesses coming, and now his ex-fling is threatening to have one of those witnesses arrested if they arrive at the courthouse. It's absolutely wild. It's all in the pre-trial document I'm going to read with you guys. Folks, there is a lot happening today. Make sure to hit the like button and subscribe. It might be, I don't want to tease this too much, it might be one of the wildest pre-trial days we're going to see here in this insane week, 5 days before the trial happens in Maricopa County. I'll be reporting live starting at 7:30 a.m. In Maricopa County time, Arizona. I will be there in full reporter mode, live streaming with you guys. We might get interviews. We're going to have people that are there, boots on the streets. We've got a reporter investigating from inside the courthouse, scones and cold brew. It is going to be a very interesting day, to say the least, but interesting does not have to wait till June 10th. I'm going to share this 25-page pretrial a statement here from her side. We're going to see specifically which arguments she has dropped. It's one thing to make a bunch of arguments on Twitter. It's one thing to be braggadocious in your blogs and threatening in emails, but it's another to see what actually can stand up in the court, and we're going to see that right now. But folks, I got to tell you something. I got this here. This is a seatbelt that someone sent me, and we use this specifically when it's time to buckle up. That being because sometimes the tea is so hot you'll slide out of your chair, or sometimes fall back right directly into that wall. Now, I'm not going to pretend that that's going to happen in this video, but I'm here to tell you something right now. If you go to my Patreon, which is a private membership community, patreon.com/Dave Neal, for $5 a month, I'm telling you right now, if there's ever 1 month to donate to the community, it is June 2024. I gave the official word, buckle up, right there. I gave the official word that today is a buckle up day. I don't say this lightly. You guys know when I say it, I mean it. So stick around for that buckle up news. It will be provided. In the meantime, I've got this pretrial statement, and then I'm going to have the pretrial statement from Clayton Echard's side. All right, in the matter of Jane Doe and Clayton Echard, so it goes into the case began as a paternity establishment case. Jane Doe claims she had intercourse with respondent Clayton Echard on May 20th, 2023. This might be the first time that she actually ever said the SI word, right? Intercourse. I don't know if I've seen this before. Prior to filing this action, Jane claimed she tested positive for pregnancy on 5 separate occasions: May 31st, June 1st, June 19th, June 25th, and August 1st. Of course, those testing positive right there were all due to HCG tests, one of which was fake sent to me. The real one did test positive at a level of 102, but we'll get into more of that later. I'm going to bring up all the evidence of fraud that I have that may be used in court to counter some of these statements. On October 16th, 2023, Jane had a lab blood test which showed an HCG level of 102. Although this test confirmed she was still pregnant, the HCG level on October 16th, 2023 was far lower than would have been expected for a viable pregnancy. This indicated Jane was still pregnant on that date, but the pregnancy was virtually certain to end without a healthy children being born. Again, that's the number right here on the right, not the one she sent to me, trying to skew, I guess, the way journalists cover this story. She faked this. She created this in Adobe Acrobat, faked it, and sent it to me and to Clayton to make him think her levels were much higher than they were. Now, we've spoken to people that have miscarried, and they said even after a miscarriage, their levels were still 100,000, that the hormone just doesn't go away when the baby is no longer viable. And again, that's not for me to testify. We'll have to see what people say about that on the day. Unsure of how to proceed, 2 days later on October 18th, Jane filed a form requesting mediation, a request Clayton did not oppose or even respond to. Jane will explain the intent of that filing was to give her an opportunity to inform Clayton that it appeared the pregnancy was non-viable and that Jane wanted to dismiss this petition once the pregnancy loss was confirmed. Despite no objection from Clayton, the court denied Jane's mediation request as premature a month later on November 19th, 2023. So this whole time she's telling people like me she's pregnant with these crazy off the charts of HCG. And at that same very time, she's trying to get a statement in that she's no longer pregnant through the court system. Sounds kind of BS to me. Sounds like she wants to have two different stories happening at the same time. Well, in hindsight, we know that facts exist, and I don't think anyone's going to buy this. In the interim, on November 14th, Jane was seen by an OBGYN facility called MomDoc, where it was confirmed she was no longer pregnant. This is also where it was confirmed she has two ovaries, which is important because she faked having ovarian cancer. We'll get into that in a little bit. After learning she was no longer pregnant, Jane filed no further pleadings in this matter and took no action to keep the case alive. Because she is not an attorney and was not represented by counsel, Jane was not familiar with the process for seeking voluntary dismissal. She assumed if no further actions were taken, the case would simply be dismissed for inactivity, as confirmed by administrative dismissal notice dated December 4th, 2023. Mind you, she's still writing articles in Medium saying she's pregnant. She's still claiming she's pregnant publicly, right? Clayton's counsel, she doesn't say she's no longer pregnant until January. Clayton's counsel first appeared in the case on December 12th, 2023, and immediately began filing various motions and pleadings without making any effort to meet and confer with Jane Doe as required by Rule 9C. This caused Jane to retain her own counsel, who immediately appeared in the case and moved to voluntarily dismiss the action with prejudice on December 28th. Because Jane was no longer pregnant, she asserted her petition was moot. This remains Jane's position today. Aside from the moot establishment petition, Clayton presented at least 2 or 3 arguably live issues for resolution. First, Clayton claims he's entitled to a judgment of non-paternity, which Jane interprets to mean a judgment affirmatively finding Clayton was not the biological father of any children. Jane may have miscarried, or as opposed to a judgment declaring the established petition moot, and or that the circumstances render any paternity issues inconclusive and thus impossible to determine. Nothing in Title 25, Chapter 6 permits the relief Clayton seeks. Rather, when an establishment petition is filed, the court may either find paternity is established, usually by applying one or more of the presumptions set forth, or the court may find paternity is not established. Again, because Jane is no longer pregnant, her position is that the establishment petition is moot, and there are no paternity establishment determinations for this court to make. Again, Clayton's argument is going to be, yeah, it's moot because you made the whole thing up. That's going to be his argument, that you never did any good faith ultrasound test or did anything to prove you were ever pregnant, and therefore we can't take your word for it. Nevertheless, as the party asking for, and by the way, don't take my word for it, we'll share what Clayton's side has to say. Nevertheless, as the party asking for a judgment of non-paternity in an otherwise moot case, assuming the court does not merely dismiss this relief as legally unavailable, Jane's position is that Clayton bears the burden of proving by admissible evidence he is biologically excluded as the father. So she's saying he needs to prove he's not the father. Again, what's he supposed to do? He can't find the biological mass she claims is a miscarriage. Again, information, trigger warning. We're going to share a very inserted photo where I believe it's completely fabricated. Completely fabricated. You know why? Because this is an outer glow halo that doesn't line up with the rest of the shadows in the photo, which means, in my belief, it was digitally added onto another image. We don't believe this is hers at all. We believe these pixels and this outer glow mean that it's clearly photoshopped. There was absolutely no way to prove that it was, ever a, biological fetus. Clayton asked the court to find Jane was never pregnant. Again, nothing in Title IX permits the court to grant such relief. However, if it did, at the proponent of that claim, Clayton must offer inadmissible evidence to prove his allegation. Again, to date, Clayton has offered nothing but pure speculation and conjecture to support this theory. Well, he did test no fetal DNA when it came. I mean, that's the hard thing. How do you prove that you're not pregnant with a baby that doesn't exist, right? That's the conundrum. The babies don't exist. Therefore, how's he supposed to say he was never the father? It's a real pickle, to be honest. Jane contends what Clayton is actually seeking is tantamount to a civil defamation claim over which his court lacks subject matter jurisdiction. For that reason, Jane's position in this court cannot grant this specific relief as a matter of law, even if Clayton had compelling facts and evidence to support it, which he does not. To be quite honest, she's lucky this isn't a defamation claim. And we'll have to see what goes on, but I would not have a problem supporting anyone wanting to sue her for defamation. I mean, anyone being these men that are wronged, even if it's not for a crazy amount of money, just to prove the point that she did harm that caused them to miss out and mess with their livelihood and their character. And she did it with, a real, malicious intent. In the amended response to Jane's petition, Clayton requests sanctions under Rule 20. Oh, not the Rule 26 sanction. As explained in other briefings, Clayton cannot receive sanctions under Rule 26 because he has failed to follow the strict requirements. To the extent Clayton incurs any fees after December 12th, those fees were not caused by any unreasonable litigation conducted on Jane's part. On the contrary, if Clayton's counsel, and by the way, what he's trying to say is all of the different random frivolous motions for lunch, and all those different things, those weren't Jane's part. Now, again, she's in response, she wanted this dismissed, of course, but also he wanted the court to know he was never the father. I think that's fair. And again, this might set precedents in the future. With the amount of AI that's going to exist out there, you could see that we're going to have to change the laws with the way we have a burden of proof set up to prove paternity and things like that. Clayton's decision to continue spending months litigating moot paternity issues is what amounts to a civil defamation case. Filed in a court that lacks subject matter jurisdiction over that claim is unreasonable litigation conduct on his part, not Jane's. Accordingly, Jane is entitled to an award of fees and costs pursuant. Finally, there is one separate issue remaining, Clayton's request for relief from the order of protection based on fraud. That issue has been fully briefed and Jane's position has already been explained. There was no fraud in this case and there is no basis to grant relief from the OOP. All right, so we're going to have to see whether or not she committed fraud. Of course, we already shared, multiple instances. Now, you might say, well, she didn't submit this fraud to court. Well, I don't operate in the court. Whether whether a Fiverr logo was shown on a document she sent to Greg Gillespie, I don't care if it wasn't in court. She committed fraud. She committed fraud on 3 different men right here. One, she faked cancer. One, she faked a Fiverr ultrasound. And to me and to Clayton, she faked an HCG test. She's really doing the cornucopia of fraud as far as I'm concerned. Psychopathic, if you ask me. Who would do this? They continue. Detailed and concise statements of... and by the way, what, are you going to sue me for telling the truth? I got these evidence. Guess what? I can print them and we can bring them to court. Let's continue. Contested facts. Was Jane pregnant at the time she filed the case on August 1st? Did Jane have any good faith basis to believe on August 1st that she was pregnant? Did Jane have any good faith basis to believe on August 1st that Clayton was the father? Did Jane continue to litigate this action after August 1st knowing that she was not in fact pregnant? What caused Jane to test positive for pregnancy 5 times? What caused Jane to have a HCG in her blood on October 16th? What was the motion for... Okay, so it goes on and on. Contested issues at law. This is above my pay grade. So these are, I guess, the questions that he's asking the court to consider. Position, and you can read all of this. I don't want to be accused of not covering it. It's just a lot, and we got a lot to get through today. Positions on each contested issue. Jane's position on each contested issue has previously been explained in other pleadings. Jane and Clayton engaged. Okay, they already got that issue. So it says that Clayton's own written admission was sufficient to cause pregnancy. That's called being gaslighted. He was gaslighted. He's never changed his claim that they only had oral. What's interesting here is they're no longer using the R word to, of course, talk about coercive types of, intimacy. So they've dropped that claim. So she's not even standing by that claim she made. Second, Jane had a good faith basis to file action. So 6 positive tests. Again, all HCG, no test of no ultrasounds, things like that. She had months to get ultrasounds. She had June, July, August, September, and October. If she was to actually lose the baby in October, she had 5 months to get ultrasounds. Never did, was never pregnant in my belief. Clayton had alleged all of the above tests are either fake or somehow unreliable, but he had 0 admissible evidence to support that claim. Well, they're unreliable because it's HCG. People test positive for HCG that aren't pregnant. It happens. It's an indicator. So Jane's normal monthly period stopped after May 2023 and did not resume until November 2023. I mean, who knows that? Jane passed tissue on July 23rd, which may have been a partial or even a complete miscarriage, although she continued to test positive for pregnancy for months after that date. Again, that's the image that I believe is not, accurate because I just believe based on my own 2 eyes that this is photoshopping right here. Very clear outer white glow, which is probably because multiple images were put on top of each other. I don't believe them to be real. They've never been verified. There's no metadata, nothing. Jane felt pregnant between May and November 2023. Oh, she felt pregnant. Well, I'm feeling like she wasn't. So what do you want? OBGYN with decades of experience, Dr. Michael Medchill, has reviewed Jane's medical record, and based on that review, he has concluded she was in fact pregnant with a level of certainty of 99% plus. Clayton's experts do not dispute or even respond to any part of Dr. Medchill's opinions. Fourth, aware that Clayton has claimed Jane's pregnancy was fake, Dr. Medchill had reviewed Jane's medications as documented in a medical record and has concluded that none of those medications would produce false positive pregnancy tests. Again, that doesn't mean that she took something that wasn't in her medical records. Fifth, Jane's conduct during the litigation is entirely consistent with a person who believes they were, in fact, pregnant. Well, look, just because she believes she's pregnant doesn't mean she actually was. Maybe she's got a mental condition where she believes crazy things that aren't true. Jane paid $725 to a company called Ravgen for DNA testing to be performed on her and Clayton. Clayton found that company, though. That's not the company she wanted to go to, and it took a hell of a lot of convincing for that to happen. Assuming Jane knew she was not pregnant in mid-August 2023, she would have known the Ravgen test was 100% guaranteed to prove she was not pregnant. It is also notable that Clayton initially promised to participate in the Ravgen test, but then failed to do so until weeks later. Had Clayton appeared for the test earlier, it is entirely possible that test results may have been different. No, that's not true because the Ravgen test needed to be done at like 12 weeks or something like that. Even if the Ravgen results were conclusively negative, which they were not, this case could have ended much sooner without a single penny of fees incurred by either party. The fact that Ravgen tests weren't conclusively negative doesn't mean they weren't negative. It means they literally don't have another way to say little to no fetal DNA. They said little to no fetal DNA. I wish Ravgen would just say no fetal DNA, but I don't know. They're meant to decide paternity, not to decide pregnancy. In light of these facts, what they should have done rather than a paternity test is like a true ultrasound. But again, Clayton tried to get that to happen. She canceled multiple times. I mean, if that's not evidence, I don't know what is. In light of these facts, no reasonable person would have agreed to perform the test with Ravgen if they believed they were not pregnant at the time. Well, one might argue she's not reasonable. The only plausible explanation for Jane's inconsistency on the Ravgen test is that she was in fact pregnant, or at the very least, she believed she was pregnant. To the extent Clayton disputes any of the above points, his position is based entirely on speculation, conjecture, and improper propensity evidence offered by two of Jane's ex-boyfriends, both of whom have restraining orders entered against them, and both of whom are strongly motivated to lie. Rumor, speculation, and inadmissible innuendo cannot support the extreme relief Clayton seeks in his case. Again, the only person who has lied with regards to pregnancy in any of these cases that we know of is Jane Doe, caught red-handed. Even if the claims of Jane's ex-boyfriends were both credible and admissible, which they are not, any statements Jane may have made during a previous relationship have no bearing on the fact that she was pregnant in this case. There's more than sufficient independent medical evidence in this case to support a finding that Jane was pregnant. Imagine if I took HCG, which I could. I wouldn't want to. I wouldn't want to put a hormone into my body I'm not supposed to have. The only time men have HCG is usually when they have like a prostate cancer or something like that. But imagine if I took HCG and I lined up 100 different pregnancy tests. I could just line them all up and I just peed and walked along the test. I could say, I've tested positive for pregnancy 100 times. Well, you would say, no, Dave, you just tripped an HCG test because you're not pregnant until it's confirmed with an ultrasound. Period. And luckily, we've got a judge who maybe she's got kids. Maybe she understands this. List of petitioner's witnesses: Jane Doe, Clayton, Dr. Medchill, and possibly her mom. We'll have to see. We'll have to see if her mom's got enough, gumption to lie or to speak her truth in court, which we haven't heard one thing from her publicly. All right. So they talk about Mike Maricini, and they talk about her objection to his witnesses. Clayton's witnesses would be Greg, Mike, and Matt. I think among others. These are the objections. As to these witnesses, Jane objects on the following grounds: lack of timely disclosure. Clayton has never disclosed a fair substance of the anticipated testimony of each witness. By the way, all these they were all disclosed before the deadlines. Relevance: the testimony of each witness is irrelevant to any material fact in the case. Well, I think they would say it is relevant because I think they would say it lines up that she's done the same thing to multiple people. Here's a statement from, I believe, 2016 with Mike Maricini, where somebody who was a eyewitness that was there with Mike, Jane Doe, and Jane Doe's father specifically remembers that the father came there to talk about Jane Doe's desire to continue a relationship. Jane had been claiming that she was pregnant, had been threatening end of life with not having an abortion. She said she was with not having an abortion if he ceased dating her. Jane had been indicating that she was contemplating, hurting herself at the thought of their relationship ending. Jane wanted me to be there. So it goes on and on. So we have multiple cases where people didn't know each other, all making the same claim. I think that's relevant, if you ask me. Inadmissible character propensity. The testimony of each witness is not admissible to the extent offered to show because an angry ex-boyfriend claimed Jane lied in the past. These men aren't angry. These men are hell-bent on the truth coming out. As to Mr. Mike Maricini, Jane further objects to him testifying for additional reasons. First, Clayton never disclosed contact information. Well, that's BS, because it appears Mike's counsel either lied about his intent to appear at trial or the person identified by Clayton's disclosure as Mr. Maricini's. So again, more just he's calling people liars. Jane has a current valid DVRO against Mike Maricini entered by the San Francisco County Superior Court. This order requires him to have no contact with Jane Doe, and he is required to keep 100 yards away from her at all times. The order contains no exceptions for in-person testimony in this proceeding, and the court is required by federal law to give him full faith and credit to the California's court. Accordingly, if Mr. Maricini appears at trial without permission from the California court that issued the original order, he will be committing a crime and will be subject to arrest pursuant to ARS 133602. This issue has been reported to court security by undersigned counsel, who has requested that Mike Maricini be arrested if he violates the DVRO as the law requires. All right, let me know if I'm reading this wrong. Undersigned counsel means the lawyer, right? So he's saying he's contacted the court to say that if Mike Maricini shows up, he is to be arrested for violating the DVRO. That is insane. And I'm going to tell you why. In a letter from Mike to a very powerful letter, which I shared the entirety of this on our Patreon, Mike explains, how the heck do you want me to call Jane Doe, the woman who attempted to and in many ways destroyed me, the same woman who continues to renew the false order of protection against me and pretends to be terrified I'll be in the same courtroom as she? Why would someone so afraid of me want to speak to me and violate that order she insists she needs? That's right, Jane Doe wanted to speak to Mike. This just a day after you threatened to have me arrested if I showed up at the courthouse to be a witness. The fact you would suggest such an inappropriate call between me and my abuser proves to me you have no idea how inappropriate it would be to speak to the woman who fabricated wild tales about me and turn them into a TEDx talk and an entry in Chicken Soup for the Soul that will live on forever. This letter, which has been painful for me to write, has addressed everything you wanted to speak to me about by phone. All the best, Mike Maricini. Then Gingras responds, saying he wouldn't have her withdraw. P.S. This goes without saying, but to the extent I suggested Mike would be arrested if he comes to court in Arizona, that suggestion is completely and totally withdrawn. So what is it, man? Are you going to have the guy try to be arrested or not? How ridiculous. Now, it's my belief that this could be something, you wonder, like, when's he going to cross the line? It's my belief this may have crossed the line into witness intimidation. That's my belief. I'd love to know what you guys think. Jane further objects to the testimony of Clayton's computer expert. Multiple experts. Jane further reserves the right to object to Clayton's expert, Dr. Deans, to the extent her knowledge, education, training, and experience do not meet the requirements of for the specific testimony she intends to offer. So they're calling into doubt Clayton Eckert's expert witness, the doctor, and they're also calling into doubt the computer expert. Clayton's computer expert, John Berryhill, on the basis that this testimony is irrelevant and offered solely for purposes prohibited by Arizona Evidence 404B. Clayton has failed to comply with the disclosure requirements. Clayton did not timely disclose it. So this, of course, is the computer expert that we hired with all of your help and money to confirm that she lied about having ovarian cancer and about an abortion she had. And that lie, has had a lot of, that lie has moved along to these images, one of which, and I don't even know which one of which she used on her TEDx talk to say this is what she looked like after suffering DV on because of Mike Maricini. She used this image in her TEDx talk. The other of these two images, I can't tell which one is which, she used to send a selfie to Mike Maricini when she was faking ovarian cancer, saying she was having an abortion. She used one to benefit Mike, and she used one to punish Mike when he no longer wanted to date her. They're from the same day. They're nearly identical images. They were taken one after each other. Telling me that's not fraud? So it goes on, and to be quite honest, I think I got to go. We got more content to make. So I'm going to continue talking. I'll probably have a live stream. They say that the good faith settlement didn't happen, didn't go through, and then they share some of the different evidence, the different exhibits and things like that. But it's wild, and he's dropped some of the claims of the big R word. That claim is no longer there, even though he had no problem making those claims, and she had no problem making those claims earlier. She obviously claimed that when she emailed me and others, claiming Clayton had done the R word. Well, she's no longer making that claim. Why? You couldn't, if it happened, wouldn't you want to, throw that in there? You're so busy making sure he's punished in other ways. All right. Well, it's going to be a wild day next week. I've got Clayton's pre-trial statement coming up next. I haven't read it yet. I hear it is really good. We'll have that coming next. And if you haven't already and you want some of that buckle up tea, go to patreon.com/Dave Neal, where we will be talking all day long in the chat room. We'll see you then.